Hello, this is Professor April Dawson, and this is a recorded lecture on the right to vote. The Constitution expressly provides for elections for members of Congress and for the President. Does the Constitution also require the election of state and local offices? And the Constitution does not expressly provide that. Arguably, the Guarantee Clause, which is included within Article 4, Section 4, which guarantees a Republican form of government, implicitly requires the election of state officers, state and local officers. But you might remember from our discussion last semester when we were talking about malapportionment, the Supreme Court reached the conclusion that a claim of a violation of the Guarantee Clause was a non-justiciable political question. So while the Constitution does not explicitly require the election of state and local officials, the Supreme Court has held that once state and local officials are selected by elections, any law denying or limiting a citizen's ability to vote must pass constitutional muster. Let's quickly run through all of the voting amendments because we have a few. So, of course, we have the 15th Amendment, which guaranteed the right to vote for African American men. The 19th Amendment, which guaranteed the right to vote to women. The 24th Amendment, which prohibited the use of poll taxes with respect to federal elections. And the 26th Amendment, which gave the right to vote to citizens 18 years or older. The Supreme Court has repeatedly declared that the right to vote is a fundamental right, which is protected under the Equal Protection Clause, and that an infringement of the right to vote must meet strict scrutiny. The Supreme Court has clearly used strict scrutiny in reviewing poll taxes, which we'll talk about in greater detail, also when reviewing voting restrictions based on property ownership, and also durational residency requirements, which we've talked about before. However, there's an argument to be made that when the Supreme Court reviewed literacy tests and laws that prevent those who committed felonies from voting, that the court did not quite use strict scrutiny, and we'll talk about those cases as well. With respect to poll taxes, so as we previously noted, the 24th Amendment, which was ratified in 1964, prohibits poll taxes in the election of federal offices. But what about the election for state and local offices? In the 1966 case of Harper v. Virginia State Board of Elections, the Supreme Court held that poll taxes are unconstitutional in all elections, including state and local, as a denial of equal protection. Note that when we're talking about equal protection, of course, we're focusing on a classification. In Harper, and when we're talking about poll taxes, the classification is wealth, and wealth is not a suspect or quasi-suspect classification. However, because what's being infringed upon is the fundamental right to vote, strict scrutiny applies. Literacy test. In the 1915 case of Gwynne v. United States, the court upheld the use of literacy test. In that case, the court did invalidate the grandfather clause, which said that anyone who could vote on or before January 1, 1866, or who was a lineal descendant of anyone who could vote on January 1, 1866, did not have to take the literacy test. And so that grandfather clause was deemed unconstitutional, but the court upheld the ability of states to require individuals to pass a literacy test before they were able to vote. And of course, we know that the whole point of grandfather clauses were to disenfranchise African Americans from voting because their descendants, who were slaves, were not able to vote. In 1959, the Supreme Court decided Lassiter v. Northampton County Board of Elections. This is a case that we actually talked about last semester. And in this case, the court upheld a North Carolina statute which required voters to be able to read and write. Interestingly, this case was decided by the Warren Court just 4 years after the Warren Court decided Brown v. Board of Education. The court concluded that literacy tests are race neutral in their purpose and effect, and that literacy tests met strict scrutiny. Are literacy tests really race neutral in purpose? And of course, we know the answer to that is no. If you look at the history of literacy test statutes, they were clearly enacted as a means by which to disenfranchise African Americans from voting. And if we're going to apply strict scrutiny, the next question is, are literacy tests necessary to achieve a compelling government interest? And while there's certainly a compelling interest to make sure that individuals who vote are informed, is it necessary that the individual voting be able to read and write? Can you be informed even if you cannot read and write? And certainly you can. You can get your information from talking with other people, from listening to the radio, watching TV, so you can definitely be informed. And you can also vote even if you can't read the ballot by having someone there to assist you. So even though the court reached the conclusion that literacy tests were constitutional, it's questionable whether strict scrutiny was really satisfied. Notwithstanding the case in Lassiter, the Supreme Court's decision that literacy tests do not violate the Constitution, as we know from our reading of Katzenbach last semester, Congress had the authority, pursuant to its powers under Section 5 of the 14th Amendment, to outlaw literacy tests. Moving on to prisoners and convicted criminals' right to vote. So in O'Brien v. Skinner, 1974 case, the court held that states cannot deny the right to vote to those who have been arrested and are being detained from voting. And in fact, the state must provide them with a means to vote, if not taking them to the polls, then to provide them with absentee ballots. However, in Richardson v. Ramirez, also a 1974 case, which came after O'Brien v. Skinner, the court held that once a person has been convicted of a felony, a state may permanently disenfranchise that individual from voting. In the 1985 case of Hunter v. Underwood, the Supreme Court, in a unanimous decision, held that if a law that disenfranchised those committing crimes was enacted with a racially discriminatory purpose, the law is unconstitutional. The problem, of course, with these felon disenfranchisement statutes is it's very difficult oftentimes to find that smoking gun, even though the law may very well have been enacted to disenfranchise African Americans. And if you have not yet had an opportunity to watch the documentary 13th, I strongly encourage you to do so. It's incredibly insightful. All right, I will leave it there. Thank you very much for your attention.